Hey guys, this is Toby Mathis with the Anderson Business Advisors podcast. I am really lucky today to have Brent Nelson, who's another attorney who does works with wealthy international clientele, and I love picking the brains of folks like that. So first off, welcome, Brent.
Thank you for having me. Always a pleasure to see you, Toby, let alone talk to you.
Hey, we could do both.
Yeah, it's even better that way. I see you've got some sort of like bar set up in the background. So
Oh boy.
I don't know why we missed out on happy hour, but I guess we'll talk about
You'll
tax
notice
instead.
the sad part is none of them are open. I just collect the bottles. I'm not
I
very
have I have a few, like not too far from me. Like I have
ah
a few bottles of wine. So every now and then, sort of towards the end of the week, I look to my left and I see them and I think, maybe this working thing is going to be okay.
it's 5 o'clock somewhere. It's time.
Yeah.
Yeah, no, I can appreciate that 100%. Yeah, I just kind of keep my hard booze over there. Every now and again, somebody points out one of the bottles and says, "Hey, is that such and such?" I'm like, "Yeah." Why is it still full? I don't really. Yeah, I'll
Yeah.
drink the wine. I'm not good on the hard alcohol. But anyway, let's talk about trust since we're talking about things that, well, I guess we can't say the hard alcohol in moderation. Maybe we should call this trusts in moderation.
Trust and moderation.
Yeah.
Yeah.
So
Yeah.
I wanted to talk.
Use with caution.
Yeah, I want to talk about all the bad stuff because I don't know about you, but I've been seeing these promoters all over the place showing you don't have to pay a tax if you put your business in a trust. You don't have to pay tax if you have your investments in a trust and all this stuff. And I remember going through this, what was it, 10, 15 years ago, where we had the pure trust and then the constitutional trust. Can we put some of that stuff to rest and just dive in? I mean, first off,
Sure.
you've been seeing it. Second off, what do you feel about it?
I've been seeing it and I feel that it doesn't work. But the more detailed answer is that, first of all, as you say, this is an idea that is not new and it sort of gets recirculated periodically, that somehow if money gets funded into trust, then therefore nobody pays any tax on the money. Well, okay, you got to take 2 steps back chronologically. First of all, you're talking about money that you earned, that you're then trying to stick into the trust, and we don't allow you to do that and escape paying taxes. We have this very nice doctrine that was created by the courts called the assignment of income doctrine, that basically says if you earn income, you must pay tax on it. You can't just shift it on to somebody else. So even if, let's just assume hypothetically, this is not true, but just assuming hypothetically that the trust did not have to pay any taxes, the assignment of income doctrine would say, nope, that doesn't work. Okay. Then just because that's not enough, we have these rules that are called the grantor trust rules that would prevent someone from creating a trust for themselves, and in many cases for their family, because they like to keep control over these trusts, and then not paying tax on it. So what happens is you put the money in the trust, say you're a beneficiary of the trust, and you think, oh, great, now I don't have to pay tax on the money, even if you got over this assignment of income issue. Well, the answer is not so fast, because the grantor trust rule pretends that you still own what is inside the trust, and therefore you still own the income, and therefore you pay tax on it. So it's a little, I know like conceptually that idea is weird because it's not reality. Maybe you really did put the money in the trust and you really don't have the money, but we just pretend for tax purposes like the trust is not there.
We like it because you could ignore the trust and you can pay the tax on it just like you own it. So an asset protection trust, it's actually kind of a handy dandy to have a grantor trust. But that's not what these scam artists are doing. These guys are going right to the, hey, this is a complex trust and I can avoid all the tax by reallocating it to corpus and all this other stuff.
Yeah.
In my opinion, they're just butchering the code. But I'm curious as to your opinion, since you're an expert in this area and you probably have to deal with it on a day-to-day basis.
I think the chances are that they are not escaping the grantor trust rules, even when they say that they are. So I think that's the first thing. People don't realize how sticky those grantor trust rules are. They exist to prevent you from not paying tax on income that's in the trust. So it's very difficult to avoid if you have any interest in the trust, or you really maintain any sort of controls over the trust. But let's just assume that you could get over that. So you're earning income and you're shifting it into the trust. You've got this assignment of income doctrine that says, nope, that doesn't work. You have to pay tax on the income. even if, let's say what you really did was you gifted in, say like business interests into the trust, and it was truly a complex trust, meaning it's a non-grantor trust.
Mhm.
Well, we have rules for that too. And those rules say that someone between the trust and the trust beneficiaries must pay tax on the income
Mhm.
for federal purposes. Okay. So even if you park this thing in a state that doesn't have state income taxes, that only solves the state income tax issue, which I think is the slight like half truth that you get told in some of these promotions, right? We can get back to that in a second, but
Yeah, they do the nings and the dings and all the,
yeah,
they're saying, hey, we can avoid California tax or something like that.
right. Which, yeah, maybe you can, but that's state tax, not federal tax. And then it also turns out that these complex trusts, if they retain the income, so they're going to pay income on the earnings, they pay tax at the highest rates at the lowest possible levels.
Yep.
And so the tax hit is not only you're not saving tax, you're paying higher taxes.
And just put it in perspective. Is it like, hey, I made 15 grand, I'm going to be in the highest tax bracket?
Yes, basically.
That's really it. That's what I just like, let's just be straight up. It is ridiculous. I forget what it is exactly. It's like around,
I think it's 14,000 something. I can't remember the exact weird inflation adjusted number right now, but
and you're at 37%.
yes. So that's not a great result.
Yeah, some promoter says this is a great idea. Let's put your business. I've had 2 clients that were 7-figure clients get pitched this with their S corps for their business so that they would never have to pay tax on that money again. And I'm like, not only would you pay tax, you're going to get killed in taxes.
Yes.
Anyway, keep going. I think
Well, that one's a really curious one, right? Because, all right, again, let's just assume they put the shares of the S corp stock into the trust. There are only certain types of trusts that can own S corp stock.
Boom.
So either you're no longer an S corp, and now you're paying corporate level tax. You're paying 2 levels of tax: C corp level tax plus tax on the dividends. So that could be one option. The other option is that you are a trust that can hold S corp stock, but it turns out that those are grantor trusts. And so you're paying tax no matter what. Like you get it coming and going, and there's just no relief. And again, this assignment of income doctrine kicks in. Anytime also, I guess we should probably note that you're trying to avoid paying tax that you owe, and you're layering in a trust as a mechanism to make it look like you don't owe the tax. Even setting aside all these fun things that we talked about, courts can freely ignore that the trust exists if it's a fraud.
Yep.
So there's also that. There's the tools in the toolkit for the courts and say the IRS who's arguing to the courts is vast.
Now, there are people that correctly can point out that there is a provision in the code about reallocating certain things like dividends, extraordinary dividends, things like that into the corpus. Is there a scenario when the trust can actually say, hey, yeah, this was shares, for example, and instead of a dividend, but it's still taxed normally, and they're saying, hey, just allocate it back into the body of the trust? Is there a situation like that where you could escape immediate taxation and it just gets added to the corpus of the trust?
No, but the answer is you're really talking about 2 completely different concepts. They're somewhat related in the trust and estate income tax rules, but when you're talking about corpus, you're really talking about what's called a trust accounting income issue, and how you account for money that comes into the trust for state law trust purposes. And so the general rule is that a dividend is quote unquote income. It may be that income is payable out to beneficiaries or not. It might not be, but you can, under most state laws and under trust agreements themselves, you can allocate those things to the corpus, which means it may not be payable out of the trust immediately. Well, that does not change the tax status of the trust at all. That's all just sort of like internal accounting for non-tax purposes. So it doesn't save you on taxes.
Yep. So yeah, sometimes people get confused because they hear the DNI or distributable net income, and they'll hear like, hey, the trust is sending it to the beneficiary. That doesn't mean that nobody's paying tax on it. It just means the trust doesn't have to get killed at the highest level, and it's taxed to the recipient.
True.
That's not what these guys are doing, though. And
No.
I had another one, and I'll just throw this one. I know I'm throwing weird scenarios at you, but there was really nice people. They were in California, and they do very, very well. They do lots of investments, and they were pitched a 3-trust mechanism. One of them being a charitable trust, a business trust, and then just a grantor trust that held the business trust, with the beneficiary being this foundation. And they were loaning the money back out, doing all this craziness. I just said it's a sham. I mean, look at it and go, first off, that's not how the rules are. But first blush, have you seen anything like that out there that you've had to deal with? And then what's your first blush on something like that?
Yeah, I can't say that I've seen anything quite like that. Although I would be very curious about how they were using the charitable trust. The transactions that I've seen, the way that it is almost always structured, and this is really where it starts to fall apart, is that let's say you have these 3 mechanisms and all of these loans. Basically, everything happens on day one, and you have to do it on, the promoter wants you to sign everything on day one. So you sign everything on day one. Well, right off the bat, somebody like you or I, and certainly a smart lawyer at the IRS, is going to look at that and say, we can ignore the fact that you have all these different parts. For tax purposes, we'll just treat it the way that it really should be, so-called substance over form. We'll just treat it the way that it should be for tax purposes. And you know what? You want to set up all these buckets and do all this complicated stuff, mazel tov, but that doesn't change the tax treatment. So you're stuck with the tax treatment, and you've paid a lot of money for this complicated structure. So you're kind of stuck with both, unfortunately.
Yeah, I actually emailed the promoter, wrote him a letter, and I was just saying, could you please just, like, my opinion is that this is a complete farce. And also, it was a charitable foundation, but it was taxed as a private foundation. And I said, you can't loan money to it.
Yeah.
But it was all in writing. That's what these guys do. I'm like, just send it to the IRS, let them know. Maybe there'll be a recovery for you. But
yeah. I think it's interesting. I think you probably see the same thing, that first of all, most of the promoters are not what I would consider serious tax professionals. That's the first thing. And the second thing is that they oftentimes like to hang their hat on the fact that everything is above board. They're like, well, we have all these documents, we've got it all papered over, and so therefore this is valid. And people need to understand, I think, the hard truth, which is, if you can do all the dumb things you want, but that doesn't mean you get the tax result you want. Mm-hmm. So there's a huge gulf between doing something that you want to do and then using it for a tax advantage and expecting the IRS to give you the tax advantage. They won't tell you have to unwind the dumb transaction. They'll just say you can't take the tax advantage.
Mm-hmm. And they'll say, hey, we don't care what you're calling it. We're going to treat it this way. It never really left the pocket. It was interesting because I had another one out here. I mean, I get hit with these all the time. So I'm just thinking of the ones that I've had in the last year. And there was another gentleman, I get on the phone with them. It's always somebody that they say is a lawyer, but it's not a lawyer. Yeah. They know a lawyer, and the lawyer had a Supreme Court decision that they rely on when they said to do it. And I'm like, what's the Supreme Court decision? And then I look at it and I'm like, it has nothing to do with what you just said.
Yeah.
Or it's something that is like from 1800s or something goofy where you're like, or a long time ago, 100 years ago, where you're looking at it going, this is not relevant, or this is not what you cited it for. This has nothing to do with anything.
Right.
It's pretty words, but
well, and that's a red flag for people too, I guess, for anybody listening. If you're getting promotions, and again, what they're hanging their hat on is that it's black and white, the code lets you do this, it's black and white. Well, just understand that, first of all, the last time there was a major change in the code was 1986. Yeah. And the IRS and Congress might have changed their minds about certain transactions. They might not have anticipated this transaction happening. So the chances, okay, let's just assume probabilities here. The chances of it being black and white in the code are not good. And there's a lot of gray area in the code. So whenever somebody comes at me with it's black and white, I'm a crotchety lawyer too. I'm just sort of like, okay, come on, really?
If it's too good to be true, you're just looking at it going, come on.
Yeah.
Somebody's going to pay tax on this. When I see this, it's always to somebody affluent, somebody who has lots of tax paying. And there are lots of ways to mitigate your tax. Mm-hmm. Paying no tax is usually not one of them. Maybe if you're a real estate professional, maybe if you have you're operating in an exempt environment, you're not, you don't, you're taking a reasonable salary or something maybe, but for the most part is no, you're not going to avoid it all.
Right.
But there are scenarios where trust are your friends. Now, maybe we could touch on some of the areas, and because you're working with wealthy folks,
Yeah.
your clientele sounds like a lot of international. When do you use a trust and for what purpose?
Well, trusts are, you mentioned one, which was asset protection. Trusts can be excellent vehicles for asset protection. In some states, you can get asset protection for yourself. So you can create a so-called self-settled asset protection trust.
Yep.
Whether those apply in every single jurisdiction, maybe a little bit of a cloud on that. But even if you don't want to do it for yourself and you want to do it for your kids, so you've put two nickels together and you've earned some money in your day and you want to spare some of that money from ever going to future ex-in-laws and things like that, you can put them in trust and get great asset protection for your family. So you can sort of protect that family wealth in the wrapper of the trust. And all you have to do is create the trust and you get the benefit. If you don't create the trust, you don't get the benefit.
Yep.
There are tremendous estate tax and generation skipping transfer tax benefits in certain types of trusts. Okay, we mentioned grantor trusts, particularly with grantor trusts that are irrevocable trusts, which basically means you're going to get the asset protection. But you, the grantor who created the trust, say for your kids, you're going to pay tax on behalf of the trust, but everything in the trust is going to be free from estate tax. So just imagine what that looks like. Because to me, if you're trying to sort of boil it down to like, what do normal humans understand? It looks like a Roth IRA. It's like you paid the tax on the Roth IRA and then it gets to grow tax-free. Well, somewhat like that, these grantor, irrevocable grantor trusts, you can set up for your kids. You're paying the tax on behalf of the trust. And then the money in the trust gets to grow tax-free, which is where you want all the growth because nobody pays estate tax on that money.
You pay, you say it's tax-free, it's growing tax-free for the estate tax, but you're the grantor. It's grantor
Yes.
trust. You're still paying tax if there's capital gains or whatnot. It's still down to you, but you're not burdening your kids. So
exactly.
We have this massive estate tax. I think you've been doing this as long as I have. Where I remember $600,000 estate tax exemption when I started. I still remember those really small exemptions, and now we're what, 12 million plus exemption.
Yeah.
So if somebody's over that, you're looking at this going, wow. Or is there a threshold that you use? I mean, it could be lower because we could be back at 1 million for all we know. I forget where it's going to go when the Tax Cut and Jobs Act sunsets, but it's definitely not going to be 12 million. It's going to fall way down there, isn't it?
It won't. It'll be half of that. So the base number right now is 10 million, and then it gets adjusted for inflation. The base number in 2026, on January 1, 2026, will be 5 million adjusted for inflation. So just round numbers, let's say it's 12 today, it'll be 6 then. So really, we're in a really weird environment where you could have somebody who's over the 12. That's easy. They need to do something. Like they have to plan for it because this tax is horrendous. Like you're pointing out, it's a 40 cent on the dollar tax. So you got a $13 million estate, you die, $1 million of it's over the 12. Somebody writes a $400,000 check to the IRS. That's painful. There is this weird middle ground right now between the 12 and say the 6, where they don't have a problem today, but if they do the dumb thing and survive until 2026, then they do have a problem. And so for those people, they kind of have to pretend that they have an issue and start doing planning. The way that I like to plan for people in that space is to try to do things that will, in essence, cap the value of their estates. So we're not going to get over 12 million. And there are a lot of techniques that we can use to take some of the assets that they own that might have variable value and actually transfer those or even sell those into trusts and convert them into something that has a very specific value. Okay, so let me give you an example so people understand what I'm talking about. So let's say I set up one of these beautiful irrevocable grantor trusts. I'm the grantor, so I paid all the tax for the trust, and you're the beneficiary because you're my bestest friend in the world. And so I have a bunch of Apple stock. I don't know what the value of Apple stock is going to be tomorrow, let alone in 2026. So I would prefer to take a promissory note that has a value equal to the Apple stock today and just hold that, because I know that's not going to change in value. So what I do is I sell my Apple stock to my new irrevocable grantor trust. The trust gives me a promissory note for the fair market value today. And now, if the Apple stock appreciates in value above the face value of the note, plus whatever the interest rate is, all of that appreciation is in the trust for your benefit. It's out of my hands. And no matter when I die, I'm not paying estate tax on it. You're not going to pay estate tax on it. And so these sorts of little valuation sort of capping transactions become really important, especially for people in between these threshold numbers. If you get above the thresholds, then it becomes really important to not only do those things, but really like give away as much as you possibly can.
Now, you just mentioned a installment sale, basically.
Yeah.
Right?
Yeah.
Are they paying it, or is it deferred? Is it something where you can say, hey, don't mess around with the interest, because we don't really want to sell the Apple stock, right?
Well, we're selling it, but because I own the stock and the IRS pretends that I own everything in the grantor trust, it's not a true
Sale.
taxable sale. So there's no capital gains. So I'm not going to pay any capital gains. It's a true sale. Like there is substance to it. It needs to be a real sale. There needs to be a real note with real interest that's really paid to me. Ultimately, the goal is to actually pay off the note at some point, but we can pay it off over time. We don't have to pay it off in the first year.
Do you put like a marker on it, like, hey, if you ever sell the stock, you have to pay back the note, and in the meantime the interest just accumulates?
No.
Is it something where you have to pay the tax, or what's the mechanism, or do you have to start making payments that first year?
We usually require at least interest payments in the first year, and very frequently the note is set up as an interest only note that has a balloon payment at the end. Say it's 10 to 15 years. We might go something slightly less than 10 years on the term of the note because it gives us a little bit better interest rate. But the idea is that once we put the stock into the trust has free use of the stock. If the trust sells the stock, and so they've actually generated a capital gain because they sold the stock, we also usually have a provision in the trust that, should I want it, I can ask and get permission, if an independent person agrees to it, to be reimbursed for the cost of the capital gains tax. So I'm not going to be burdened with the capital gains tax that I didn't want to pay.
Because it's still a grantor trust, so I'm
Right.
still responsible for any of the income. If there's dividends paid out of Apple, for example, they pay a small dividend, but then would that also be taxable to me as let's say it's the parent for a child, instead of just really nice to me and giving me lots of stock, although I wouldn't stop you.
You wouldn't stop me. Okay, good to know.
But you're still paying the tax on that, right? You're not.
That's right.
And if I need to pay interest, is it something where I could continue to make additional contributions to the trust in case there needs to be cash that's paid out as interest? Or how does that work? Do I have to sell stock to pay that interest?
Hopefully not. The idea is actually what you would do is first, when I create the trust, I would seed the trust with other investments.
Right.
Maybe it's cash, but maybe it's other investments. I like to seed it with something that has a return on it, so that collectively the return that we can get on those assets plus the thing that I'm going to sell into the trust is far more than the interest that's going to be paid on the note. I don't want to overly burden the trust. I don't want the trust to be uneconomical. And of course, what I'm trying to do is put more money into the trust. I don't want the money coming back to me. I want as much in the trust as possible. So if a really good example would be, if I have, say, some real estate that's rented out and it has a pretty good stream of income on it, I might gift that into the trust first, because the income off the real estate is going to support the promissory note in the future.
But either gift it or sell it, or I understand what you just said. So you're gifting the entire real estate in there so that the income stream covers the interest on the note.
Yeah, or it could be a mix. So maybe I gift a part of it and then I sell the balance in, but just so that the assets collectively between what I sell into the trust and what I gifted into the trust are able to generate plenty of income to support the note payments. Because I don't want the trust to be uneconomical. And I want the note to actually be paid off at some point. Real estate's just great because it often has a relatively consistent stream of income. It can be used to do future financing. So if the financial terms are appropriate, you might be able to suck some equity out of the real estate, pay off the note, and now you're just paying back the bank, but you're going to pay off the bank over probably a longer period of time than my promissory note. Those sorts of transactions then are possible in the future with something like real estate.
That's really smart. And then it sounds like if somebody's over the $5 million mark, they might need to consider this. And would it be business interests, stock, real estate? Just maybe they're getting a portion of it that might be highly appreciating, or, it keeps going up in value, that they just kind of want to freeze it so that they don't have an estate tax issue. Is that primarily what we're doing here?
That's what we're doing. And it would be all of the above.
Yep.
Yeah. Obviously it depends on what somebody owns. The first question I almost always ask a client is something along the lines of, how much can you afford to give away? Like, what do you need to live on? Because we also are not asking clients to do something that then impoverishes them in a way that substantially affects their quality of life. I'm not saying super lavish lifestyles, but I want them to be able to like live comfortably the way that they enjoy living. And so we're trying to come up with strategies that can generate streams of income coming back to them from these trusts that will in reality support the lifestyle that they want. I want them to also maintain enough funds outside of the trust so that if everything goes south in the trust transaction, they have enough money to take care of themselves, of course. But I don't want to do something that is unreasonable because it just doesn't really work for their lifestyle. So we're always trying to match up payment terms and assets with the reality of the client's lifestyle.
Now, shifting gears slightly, is you mentioned international clients. So you have wealthy international clients. Are we talking just U.S. citizens, or do you have folks that are non-citizens too?
Both. Yeah.
And
both.
yeah, so if you're a U.S. citizen, you get the benefit of the U.S. estate tax, these huge amounts, the 12 million right now, and in 2026 going back down to the 5 million index for inflation, which will be around 6 million. Mm-hmm. What about the international folks? Because they don't get the benefit of that, do they?
They do not. So if you are not a citizen and you're not a resident, and resident means you don't live here with the intent to stay here, you're not a so-called domiciliary of the U.S., then your estate tax exemption is $60,000, $60,000. Yep. And that number has existed since the 30s and they're not changing it. So, and it's not indexed for inflation. So no one is coming to the rescue. These people don't vote. Okay. Yes. So nobody's helping them.
So I'm somebody, let's say that I'm in Spain and I own $1 million of US real estate. Am I going to be paying 40% on that $1 million minus the 60,000 exemption?
Unfortunately, yes.
What if I'm married to a US citizen? Do I get any reprieve, or am I still going to get hit?
So in that case, if you leave the property to your US citizen spouse, you get the benefit of what's called the marital deduction against estate tax. And that's a dollar for dollar deduction for all the value that goes to your US citizen spouse. So you would pay no estate tax at your death in that case. And in essence, the policy is, great, now the property is in the hands of an American, we can tax Americans. So we'll expect that we'll tax the spouse later on. Of course, now the exemptions are so high for Americans that it's not as useful, but that is still the policy.
Do you see this scenario play itself out? Is this something that you have folks come in and they're like, I have $5 or $6 million real estate in the US. I'm not a US citizen. I don't intend to reside here. I'm not married to a US citizen. I just own a bunch of real estate here. And is that something you see?
I do. And when they have done the thing and bought all the property before talking to me, that's a real challenge because it's hard to back out of that transaction without paying tax on some level. Mm-hmm. Usually what it requires is swallowing a somewhat bitter pill and paying capital gains tax in order to avoid later paying estate tax. And the reason for that is that the typical way to plan around the transaction, well, there's really two ways. The first way is for a non-citizen, non-resident of the US, it's important that that is what they are. Okay, this doesn't apply to US citizens. If you set up a foreign company that's viewed as a corporation here, and you own stock in the foreign company and it owns the US real estate, When you die, we pretend you only own the stock in the foreign company and not the US real estate, so no estate tax.
Yep.
But in order to back into that structure, when you already own the US real estate, you have to pay capital gains tax.
You're going to have to sell it to the corporation, right?
In essence, yeah. It doesn't mean
Uh,
it doesn't mean there's like an exchange of cash. It's just we pretend that it's a sale when you contribute it to the foreign corporation.
and then how would this change if you do have a US citizen spouse?
Yeah, it's a little easier when you have a U.S. citizen spouse because of the marital deduction, but you end up in there's a little bit of a logical conundrum because you're guessing on who's going to die first.
Yep.
If it's the foreigner, you're fine. If it's the U.S. person, then you got a problem. The other way that we usually handle this problem, if we don't want to pay capital gains tax, is we simply have the foreign spouse buy life insurance if they're insurable, because proceeds on life insurance on the life of a non-citizen, non-resident of the US, very important that that's what you are, because it doesn't apply to US people, but the proceeds on life insurance on that type of a person are not subject to estate tax. So we buy the life insurance to cover the estate tax in the off chance that foreign person dies second, not first.
Very, very interesting. What if does it change if they are a resident, they have a green card? Maybe they have a 10-year green card or something along those lines. Does it change everything under those circumstances?
It totally flips everything on its head.
Yeah.
And so, of course, it's like, yeah, you got a green card, great. You can't vote, but we're going to tax you like a US citizen. But that means you get the benefit of this $12 million exemption as well. So
you get it. Okay. So, all right. So if you have that green card, that's your reprieve. If you become a non-resident, so your green card's for 3 years and it expires, now you're back in, oh, heck.
You could be. And well, in the meantime, the fun thing is we pretend you're a citizen, so we tax you on all your worldwide income. And so we kind of get it from some angle. And then there are some very specific rules about long-term green card holders. So if you hold a green card for more than 8 of the last 15 years, and then you give it up, under some circumstances, we charge an exit tax. We pretend you sold all of your assets, and then you have to pay capital gains tax in the US on your way out.
That's I think that's some Canadian friends that I know here, is that they were dealing with that when they were about, I'm going to go back. And then they were like, I'm not going to go back.
Yeah.
Because the tax is so heinous. Yeah.
It goes both ways. Canada has its own exit tax. They actually call it the exit tax. We call ours the expatriation tax, but they functionally are the same, where when you're a Canadian resident and you come down here and you become a US resident, you have an exit tax to pay in Canada.
Yeah.
And
oh, sorry.
I was going to say, and it can be kind of painful. So Canadians who accidentally trip up on the Canadian exit tax are not happy.
Yeah, because the CRA is not a pleasant organization.
No.
The other fun one is when they put things in trust. Don't they treat it, for Canadians, they treat it as though they sold the asset too, right?
They do. Yeah. If you're a Canadian resident and you create a US trust, because that's what your very smart and well-meaning US advisor told you to do, it's a deemed sale of the asset to the trust in Canada. So you pay tax in Canada. The US doesn't care, but Canada really cares.
Canada's blame Canada.
Exactly.
So I guess the moral of the story, and I could talk to you all day about this stuff because I find it fascinating, is it's complicated.
It is very complicated. Yes. Unfortunately, it is.
Yep. And if you have a green card, if you own substantial assets and you're non-US resident, non-US citizen, you need to talk to somebody who knows what they're doing. Mm-hmm. If you're a US, you reside here and you have assets over $5 million, you need to talk to somebody who knows what they're doing on this precise issue, because it sounds like it could be a nasty ramification.
Yes.
I want to ask you one last question. This is a softball because I know you and I think the same way. But there's also these revocable trusts that are floating around out there, most notably the living trust that we oftentimes hear about. And I just want to get your take on people that do wills versus living trusts versus do nothing at all.
I'm not in favor of do nothing at all. So to be perfectly clear, my number one preference is to do a living trust or revocable trust at a minimum. And that's for almost every single one of my clients, regardless of how much money they have in the bank or in the company. Okay. So
God, I wish more lawyers said that.
the thing that really keeps me up at night is the nightmarish guardianship and conservatorship files that I have that exist because somebody didn't do a very small amount of planning and do what could have been a extremely simple, in inverted commas, simple revocable trust that would have resolved an issue of what happens when they become incapacitated, who's going to manage things, or what happens if you die and you leave money to a minor, who will manage things for the minor. If it runs through a revocable trust, it just solves all those problems. And there's so much headache that can be resolved just by doing this very simple thing that I see almost no circumstances where it doesn't make sense. The biggest caveat to it, honestly, is usually with foreigners, where their home jurisdiction has a rule like Canada that says doing a trust is a deemed sale. Setting that aside, it's almost always the right answer.
And does Canada always tax? So if you do a living trust in the United States and you're a US citizen, but and all your assets are here in the US, would Canada still hit it?
If you're a US citizen and not a resident of Canada, then you're okay. But if you're a resident of Canada and you're doing a trust here, in most instances, they'll treat it as a sale of the assets to the trust. There are some very small carve outs for like elderly people who are doing basically revocable trusts. They call them bear trusts in Canada, and those trusts escape these rules. But the general rule is, you have to.
It's over a certain age, right? I believe it's over a certain age.
It's 65 and older, if I remember right. Yeah.
Yeah, I think I remember seeing that. It's in the recesses of this brain. But I want to hit on the living trust just one more time, because a lot of times people will go to somebody and they'll say, just do a will. And I'm always like, that's comparing a Happy Meal to buying just the burger. Oh, you can just buy the burger. The Happy Meal comes with other stuff.
Yeah.
And the other stuff is sometimes what's really important. And so you just talked about doing guardianship files and conservatorships. That's always included in a living trust. I've never seen a living trust that did not have power of attorneys for financial and in health. And I've never seen those attached to just a will. Sometimes somebody will do both, but usually if you're going through the trouble, you're either doing the estate plan or you're not.
Mm-hmm.
And that's the part that just bugs the heck out of me, because I see that over and over again. Because again, it's like, should I have a meal or should I have a soda pop? And they said, well, the soda pop's perfectly filling, but they're two very different things. So when somebody says, should I do a will or a living trust? I always look at it going, they're different animals. And like you mentioned some of your files, like how arduous is the process of getting to become somebody's conservator or taking over their finances when there isn't a written document? Is it pretty heinous?
Well, in my fine state, which is similar to most states, somebody who cares enough about you has to file a petition with the court. The court appoints somebody to sort of be an investigator and talk to all of the interested parties and submit a report to the court. The court appoints a lawyer to you who is now incapacitated. So at least two lawyers are almost always involved. The court appoints a medical professional to do a medical examination. All of this gets submitted to the court. You have a public hearing on your inability to manage your finances, which may not be very pleasant. Mm-hmm. Then somebody gets appointed. Then every year they have to account to the court down to the penny everything that has come in and out of their hands on your behalf. Wow. And they do that for your lifetime or until you're cured, which is not usually the case. So
if you have somebody with dementia, if you have somebody that was in a car accident and for whatever reason can't make decisions on their own behalf, maybe they're brain dead, right? You're gonna have to go through this process even under those circumstances.
Yeah, dementia definitely, car accidents definitely. Dementia one, that's easier to plan for and plan around. If somebody gets in an accident and say they end up with a personal injury settlement, that can be hard to plan for and plan around, and you may be forced into one of these conservatorships, but they are just very burdensome and very time consuming. And when people hear time consuming, they should think expensive. Yes. That time is being charged by the hour.
But a will is easy, and probate's not bad in my state. I mean, I wish I had a nickel. Probate's not bad in my state. Oh, you don't need that. And you're just like losing your mind. All right. So I think we think alike on that one.
Yeah, we definitely do. Well, the other thing is they say, well, I have a power of attorney that takes care of it. And which is totally fine. It's just that the banks don't always agree. And so if the bank doesn't agree, your power of attorney is worthless.
Yep.
And that happens so frequently. And sometimes people don't believe me, but that is the case. It's happened plenty of times, just say over the last 10 years, that I could say with full confidence, banks hate powers of attorney.
Yep. Do the trust.
Do the trust.
And I've dealt with the same thing you've dealt with. And it's like,
yeah.
But they're covering their backside. They've obviously been disastered in some circumstances. And, ultimately, I don't think anybody's acting with ill intent. They're just trying to do what's in their best interest. And it's not easy. So make sure you got your bases covered and make it easy. Anything else you want to hit on? I've really enjoyed our conversation. So I'm just curious. Anything else you want to add?
I guess the only thing we didn't mention, this is along the lines of the conversation we had at the beginning about all these fund promoted trusts. If it's a trust that's in a foreign jurisdiction, just know that your antenna should go 50,000 stories high, because it probably doesn't work.
Oh my gosh. We didn't even get into, I don't know about you, but I've had multiple clients go to me and say, I'm going to do this trust. This trustee's been in business since the 1800s or something weird. And then they come back a couple of years later going, my trustee won't respond. How do we get my money back?
Yeah.
I've had that on more than 3 occasions. Like, I can think of just a few of them right off the top of my head. Have you dealt with that too? And you said your antenna goes up. Is that one of the reasons, or are there other reasons too?
Well, one reason is just because the way that they're promoted is not the way they actually work. It's like this, it's supposedly some sort of tax move. It's not. Just surprise. You don't have to wade through the details. The surprise ending is it's not a tax move. You don't save taxes. You usually complicate your taxes is what happens. And then, yeah, nightmare scenarios do happen. I mean, one of the most egregious cases that I had was a client who had a trust that was set up actually by her husband. And there were 2 individuals who were the trustees, and they basically just completely mismanaged the funds and stole money. Mm-hmm. And it took years to run them down. It took years to get rid of them. And we literally still have in the investment accounts 1 or 2 Irish mutual funds that were frozen during the Great Recession. Not great investments to begin with, but they were frozen during the Great Recession. We cannot recover the money. That was, 2009, 10. And we still haven't resolved it.
And again, there's enough nightmare stories of the trustee quit responding. Where is this trust? Isle of Man or Cook or one of the, some island somewhere. And I'm like, well, you're going to have to go there.
Yeah.
It's going to be expensive litigation if they're still there. But chances are they just disappeared with your money. I'm not a big fan going offshore unless you have a really good reason. But that's interesting. Again, you and I think more alike than I realized on a lot of these, just from what I see. Because boy, we see a ton where somebody comes in and it's some promoter, go to this island, go to that island, go over here, go over there. And I'm like, do you have business over there? Do you have people over there? Do you have an infrastructure over there? Because
right.
It would be really, really bad if you have to enforce over there. It's going to be tough. You have no infrastructure. Are there any situations where you do go offshore?
It tends to be non-Americans. So foreign clients who are, say, investing in the US, we might set up a trust for them that's a non-US trust, although we set up plenty of US trusts for those people. But sometimes it's better to set up the trust in a foreign jurisdiction because their home jurisdiction and that jurisdiction are more friendly to each other than that jurisdiction in the US. And so we'll use the foreign country to set up the trust. That's really it. I mean, frankly, the US tax laws and the US trust laws are so good and so robust, and it's such a good environment for investments that very frequently the trusts are here, even for the foreign clients.
Yep. My experience too. US, it's hard to beat.
It is.
We tax worldwide income. So yeah, like you're not gonna move it outside the US and somehow still have access to it and get it.
No.
But why would you? Buy the asset, let it appreciate. You can borrow against the asset. It's going to step up when you die. I mean, there's just so many other benefits that are floating around here in the US tax code. It's like, why go mess around overseas unless you're Amazon? Or
Yeah, well, I know I hit that from people sometimes like, well, what about, Amazon and Apple and all these companies? And I say, you're not a company.
Yes.
So just you're playing by a completely different set of rules. What are you thinking?
And they've been hit with like billion-dollar fines to Apple.
Yeah.
Getting crushed.
Yeah.
It's the intellectual property, and they're doing, I forget what it was, like Isle of Man or Liechtenstein. I mean, there's places that people go, but yeah.
Just you're an individual. Don't, it's not worth it.
Yeah, you don't need your team of lawyers to go overseas and try to argue why you shouldn't pay the tax that they're trying to assess on you that you set it up to avoid.
Yeah.
Sometimes it's easier just to keep it simple.
Indeed.
Brent, how does somebody get a hold of you if they want to reach out?
If they Google Brent Nelson lawyer, they'll probably find me, but I'm a partner at a firm, I should say, called Ramon, RIMON. I live in Tucson, but the firm is an international firm of about 180 lawyers or so. And then I'm on social media at Wealth and Law, all spelled out. And I have a podcast, the Wealth and Law podcast. And
Excellent.
that's on all the normal podcast aggregators, Apple, Spotify, etc. So anybody looking for me, they can find me. The Googles know I exist.
I'll put you in the show notes too, and make sure that we put a link so that they're easy to find you. The world needs good people like yourself. We have some crossover, but I have no problem saying reach out. If you're somebody who's over that $5 million mark and you want somebody who knows what they're doing, this is what guys like Brent do all day. And you want somebody that knows their stuff for 100%. But I really appreciate you coming on and sharing with us. I was going to call this trust scams and things to avoid. And we all see them. And every time somebody comes running in and says, I don't have to pay tax, this guy said that, I'm always like, oh no, not again.
Yeah, not again. Exactly. Well, I let me give the compliment the other way too. So if anything I said makes somebody think they need Toby's services, great. So that's fine. The world is abundant. That doesn't bother me at all.
Yeah, never a worry here, but I just appreciate you sharing.
Likewise.